I had seen him in the morning on the one case and then found out that afternoon that he was being arraigned on a new case. And so I told him to hold him because I was not aware that there was even a new case when we had seen him earlier. Court calls case people versus LeJean Vinston. Oh, who is this? Sewell? I'll just do that. I got all kinds. Court recalls case people versus Sewell.
Mr. Canatra for the people. Thank you. On behalf of Jarrell Sewell. Mr. Sewell, could you please state your name?
Jarrell Sewell.
Thank you.
Okay, I figured out what happened. What happened was I had seen him in the morning on the one case and then found out that afternoon that he was being arraigned on a new case. And so I told him to hold him because I was not aware that there was even a new case when we had seen him earlier. That's why his bond was denied on that.
Your Honor, our request stands. We're just asking for some cash bond to be.
Did I deny it in?
It was the controlled substance one, the 23 FB matter.
Yeah, that's the one that's denied. All right. I'll give him a bond, $25,000 cash surety. Court calls the case. There. People versus Eddie Collier Green.
And Matthew Mansour, Assistant Public Defender. On behalf of Mr. Eddie Collier Green, who approaches. Please state your name for the record.
Eddie Collier Green.
Your Honor, we're just requesting a 1 week adjournment. Discovery is almost complete. So you just need 1 week, please.
Just these the only things holding him?
These 4 files, to my knowledge, yes, Your Honor.
And everything's gonna be ready in a week. If I put it,
Yes, Your Honor.
probable cause conference will be adjourned to, what is that? April 25th, 2024, 9 a.m. Bond continued.
Judge, can I just address that briefly?
You may.
Is there a no leaving the state of Michigan as a condition on release?
It is a standard condition that can't leave the state of Michigan, so yes.
Okay, I just want to make sure that if he does.
Yes. That's what it indicates. He cannot leave the state.
Okay, Your Honor. So if I can re-ask when the next court day was for the adjournment? I'm sorry.
1 week out, 25th.
Thank you.
Your Honor, I'd like to address the court, please.
You want to address the court?
Yes, Your Honor.
Just give me 1 second, Your Honor, please.
Sure.
But I don't leave it up.
Your Honor, he wants to speak with you.
Thank you, Your Honor. Last time I seen you, Your Honor, in 2022, you released me on the PR bond with the bond conditions of not contacting my ex-wife, staying out of Ann Arbor, and staying out of Michigan. Currently, I do not live in Michigan, Your Honor. I'm a resident of Syracuse, New York. And currently, I'm to start working May 1st. If I was to post bond, I have nowhere to go here in the state. And currently, I'm not a flight risk, Your Honor. When I was apprehended by the U.S. Marshals, I waived extradition and I came right over. I just got out of prison in Ohio, Your Honor, and I had a 2.5-week vacation, able to get some things together, and I was able to secure a job and take care of some health things. So if I am able to post bond, which I'm not sure if I am, I don't have anywhere to go here in Michigan.
Okay, I understand that. So the condition of your bond is you cannot leave the state without the permission of the court.
Yes, Your Honor.
And so I'm not granting that permission at this point. So prior to posting, you might want to make sure you talk to counsel and seek some relief from that particular part of the order. But I'm not just giving it.
Thank you, Your Honor.
Thank you. Bond continue. Court calls case people versus Brighton. Is it Brighton Warren?
Morning, Your Honor. For the record, my name is Jeffrey Bennett. I'm appearing with and on behalf of Mr. Warren today. Mr. Warren, can you state your name for the court, please?
Brentford Warren. All right, what are we doing?
Your Honor, at this time, I do have all discovery. I am requesting a preliminary examination, and at the appropriate time, I'd like to address.
People would have their witnesses available the 30th. Preliminary examination will be set April 30th, 2024, 9 a.m. in person before Judge Before Judge Barr. As the bond.
Your Honor, the bond is currently set at $250,000 cash or surety. The most significant charge is assault with intent to commit great bodily harm, murder. The allegations in that are that the alleged victim threw a bottle at Mr. Warren. He grabbed her hair and she put her to the ground, and as she did, she hurt her wrist. He does have a criminal history, but he is a lifelong resident of Ypsilanti. Resides now with his mother since him and the alleged victim have split up. He's employed, does DoorDash and Uber. He does also have a child, which is the alleged victim in this case in the area who he's been seeing and trying to support. And he also has a support of I believe that $250,000 is an excessive amount of bond. I would actually request the court to lower the bond at a condition of a GPS tether, and we could certainly geofence him away from this alleged victim's residence and work.
Response.
Judge, the defendant was recently released from parole, for serving a sentence for manslaughter. He was on camera in this offense, damaging the security system. He actually broke it. He tried to remove the third door camera from her house. He punched it several times, removed it. He broke the victim's wrist in the incident that defense counsel is talking about, where he pulled her to the ground by her hair. Her wrist was broken. She finally made a police report to the police when he damaged her tires and slashed her tires, and that's when police were involved. I have serious concerns for victim safety. The police officers have serious concerns. They actually called me on the weekend on this case, extremely concerned about the victim and the stalking behavior of the defendant, that he just wouldn't leave her alone. I believe bond is reasonably set. He actually asked for a $500,000 bond at the time of arraignment. So I'd ask you not to change the bond. Thank you.
Anything else?
Your Honor, the allegations that rise to the stalking are alleged to have occurred over a long period of time. These charges miraculously appeared after Mr. Warren addressed the fact that the complainant had taken his tax refund check. The day after that happened, we get a slashed tires and a call to the police. So I know that Mr. Warren has no interest in being around her. He certainly denies all the charges, by the way, including the assault. But I'm just going based on what her allegations. This is something that the most serious allegation is the GBH, and that incident, which I don't even know when it happened. It's not in the report, was triggered by the alleged complainant. I believe that a lower bond with a GPS tether is adequate to protect.
Did he just get off of federal parole?
No, state parole, Your Honor.
State parole?
Yes,
So he was just released from parole. When was he released from parole?
July of 2023, I believe, right?
When I was released,
Parole violations.
no parole violations.
Yeah. He served 7 years and
There
2
haven't
months
been
on a
any
manslaughter and had no parole violations while released on parole.
Right, I understand that, but then within this behavior, at least according to the allegations, begins within 4 months of the time that he's released from parole.
That's when the allegations arose.
Right.
I certainly have a different view of what these allegations are.
All right. Well, everybody can sort that out then maybe on the 30th, but motion for bond reduction is denied. Bond. Thank you. Let's call the case, People versus Benjamin McFadden.
Assistant Prosecuting Attorney Morgan Burrows on behalf of people.
Public Defender Hannah Holstring on behalf of Mr. McFadden. Your Honor, can I have one moment briefly?
Do I have a choice?
Thank you, Your Honor.
Oh, okay. Yeah.
Your Honor, we are asking for an adjournment of the probable cause conference.
Probable cause conference will May 2nd work for.
Yes, please, Your Honor.
May 2nd, 2024, 9 a.m. bond continued.
Your Honor, I do hope to address bond.
Oh, I'm shocked. Go ahead.
In this case, we requested $250,000 cash secured, $5,000 bond, as well as, I believe, no GPS tether in this case. He is currently on probation for assault, which he was convicted for in August 28th, 2023. That was reduced from an ag assault. That he was on probation for that when this offense occurred. Since this offense has occurred and he was out on bond, he has since been charged with witness intimidation and aggravated stalking for continuing to contact the victim in this case.
I'm just trying to make sure. So he posted on this,
Correct.
he's out,
Correct.
and now there are new charges.
For witness intimidation and aggravated stalking. He has not been arraigned on that. The expectation is that he will be arraigned on that later today. Additionally, we charged him in late March for larceny in a building. It is important to note that that offense date is from July of last year, but he does have 2 new felonies coming. He has not been arraigned on that either, but.
Well, hold on. When you say he has 2 new felonies coming, those are the new ones. Okay, gotcha.
So with all of that in mind, I do think that the $5,000 that he was given in this case is not appropriate. We would have asked to address bond today, given the fact that we initially requested $250,000, had the witness intimidation and aggravated stalking not been added on or had not been a new case. But given the continued threat to the victim and the greater community in this case, we would be asking for an increase in bond.
Any response? I guess.
Your Honor, no response at this time.
All right. I will increase the defendant's bond. I certainly will take a look at it, but one thing is that if this allegedly occurred while he was on probation for another offense, especially if.
Your Honor, I do think it's important to note that this incident, the actual assault, DVH, strangulation, and FA that we're here on today was a report from the hospital because the victim had such severe injuries that she was admitted to Trinity Health ER. The defendant picked up the victim, shook her, slammed her onto a glass coffee table, breaking the coffee table, grabbed her by the throat, putting pressure on her chest. He gripped her by the throat, placed his forearm on her throat, and she was only able to get him off by taking him off of her, but he came back at her with a drill fork, held it to her neck, and said that he would kill her and then kill himself. She was so scared that she didn't initially make a report to law enforcement. It was only after she started, law enforcement, or she told law enforcement that the defendant was stalking her and continued to call her that she decided to actually tell law enforcement his name. So we have the compounding concern of the threats, the injuries, and the continued pattern of behavior in this case.
And the allegations of witness intimidation when this individual got out, those are.
From April 5th to April 12th.
But those go directly to the alleged victim in this case?
Correct.
Anything, Ms. Apple, or no?
No, Your Honor.
Defendant's bond in this case will be set in the amount of $200,000 cash surety. Well, and if the defendant does find a way to post, there will be a home confinement GPS tether. And I'm signing that order. So if he does post, he's on a home confinement GPS. False case, People versus Nicole Bigham.
Andrew Childers, attorney on behalf of the people. Assistant Public Defender Jay Bellinger on behalf of Ms. Bigham, who stands to my right. Ms. Bigham, can you please state your name for the record? Your Honor, there's a lot of discovery to review in this one and also to collect. If we could just ask for 3 weeks on this matter.
Hearing no objection, May 9th, two
Thank you.
2024, 9 a.m. bond continued.
Thank you.
Recalls the case People versus Aaron Bowers.
Again, Your Honor, Andrew Meyer on behalf of Aaron Bowers. Mr. Bowers, hopefully we can hear you now. Can you state your name for the record?
Aaron Joseph Bowers.
There we go. Speaks.
Yes.
I
I have before me a plea form. Is that what we're doing?
That's correct, Your Honor, and we've
Gonna
reviewed everything.
plead No contest to a charge of larceny 200 to 1,000 to 1 year offense. On a successful plea to that charge, count 1 would be dismissed. There's further agreement that the defendant would pay $5,666 restitution, $5,066.66, if I didn't say that right.
Yeah.
Restitution, and that there is no delayed or deferred sentence.
That's a correct recitation of the plea agreement. We did review everything, including his trial rights.
That's correct, Your Honor. That is.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record, please.
Aaron Joseph Bowers, Your Honor.
All right, sir, it is this court's understanding that you are going to be pleading no contest to the charge of larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. That's greater than $2,000. That would become the maximum fine. You understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, let me explain 2 things about it just to make sure that you understand. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Lack of recollection, Your Honor.
So, sir, to the charge of larceny 200 to 1,000, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Probation, Your Honor.
All right. Were you on probation at the time of this offense?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been handed in and has reviewed Michigan Department of State Police report for their incident number 2933-22. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
The defense is satisfied, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1483 probation. 1483 probation. Sentencing in this matter will be
May 20th at 9 a.m. before Judge Freshour.
May 20th, 2024, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will continue. Thank you. Thank you, sir.
Thank you, Your Honor.
Bowers will be in touch.
I'm going to reduce your bond to a personal recognizance $5,000 bond with the admonition, I dare you not to show up.
Thank you, Your Honor.
So you got to come and see me on the first, on your misdemeanor cases, on the ones that are currently misdemeanors, and you got to come back on the second here.
May 1st?
So you got 2 days in a row.
I'm not sure what time, but I know I got,
See, this is how you go.
no.
Yeah, I should
I
just
got
keep.
an FOC on the first too, but I'm not sure what time though.
You got a friend of the court?
On the first, yeah.
I can,
See, this is how he was gonna mess it up, you know?
well, he's gonna be
Well, I'm
He
not
would
here.
have
sure
gone
what-
down to the front of the court or not gone to
I'm not
the
sure if
court, got locked up. Then next thing you know, he would have, see, man,
Well, he said he'd be here, Judge. He didn't say he'd be there. So he'll be.
what?
He said he'll be
Yeah,
here.
FOC can always.
Yeah, but then they'll be looking for him.
That's true, Judge. But he promised you he'd be.
What time is your FOC hearing?
I'm not sure. I just know
It's my
on the
office
first.
representative.
Okay.
It's not a case, it's just a show cause.
Okay. I assume my office will probably be assigned to help him with that, Judge. I'll speak to Mr. Kincaid and see what we can do to try to assist with that, Judge.
All right. I give him my ammunition. If he doesn't show up,
Be here, the first and the second, 9 a.m. Thank you, Judge.
Thank you. Honor.
I will come find you. Court calls case, the people state of Michigan versus Carl Hearns.
On behalf of people.
Ready again, Judge. Portia Feaster, Assistant Public Defender, appearing on behalf of Mr. Hearns. Mr. Hearns, please state your name for the record.
Carl Hearns.
Thank you.
Spoken to my client, Judge, and to Ms. Willen on this file. My understanding is this is a reissue. I would need to adjourn this matter because our office did not have this case filing. So I'm not sure if there was a conflict or how we did not have it then, but we do have it now. So I want to kind of figure those things out, Judge, to make sure we're not representing him and there's a conflict. Judge. That makes sense. I hope.
Well, no, it didn't, but
Okay.
I got you. No, I understand what you're saying.
All right.
It doesn't make, right. So how much time did you?
Just a week or two, Judge. I'll figure this out and I'll find out what happened if it is ours and try and see what. How,
Probable cause conference, May 2nd, 2024. 9 a.m. Bond will continue. Court does call the case People versus Miguel Grammatical.
Good morning again, Your Honor. Andrew Meyer on behalf of Mikhail Grammatico. Mr. Grammatico, could you state your name for the record?
Mikhail Grammatico.
Thank you. Your Honor, this is the time and date set for a probable cause conference. Mr. Childers and I are discussing a potential resolution, but I think we just need about 2 more weeks to get there. So an adjournment is what we're asking for.
Probable cause conference will be adjourned May 9th.
And Your Honor, I did have one hopefully minor issue to address on bond.
He's out.
Well, I understand that. but it's a
Okay,
condition.
go ahead.
Mr. Grammatico resides in Holt, Michigan.
Where?
Holt, Holt, right?
Yeah, it's
Okay.
over by Lansing.
I know where it is. Good.
Did I say it wrong? I mean, you guys.
No, I just didn't
You
hear.
guys call Mylan. So he's having some difficulty in terms of testing and getting back and forth. He does have a facility closer to his home called AverHealth that he could test at. I'm just asking for permission for him to do the testing there and have the.
I'll indicate
results forward.
defendant may test closer to home. I leave it to community corrections to make sure that the facility is adequate or appropriate.
So go across the street.
But I have no problem. You have to make sure that you sign releases to make sure that whatever facility it is sends the results to community corrections timely. You understand that?
Yes, Your Honor.
All right, his bond will continue. I'll put that on the file here that he can.
Thank you, Your Honor. We appreciate that.
Thank you.
All right, you may just want to double check while you're here. All right, we'll see you back on May 9th.
Court calls the case People versus Dominic Kelly Payne.
Ready, Judge? Assistant Public Defender, appearing on behalf of Mr. Kelly Payne. Mr. Kelly Payne, please state your name.
Dominic Kelly Payne.
I've spoken to Mr. Kelly Payne and to the people on this matter. He met with our social worker again yesterday. We're asking for the shortest possible adjournment of the PCC. Come back next week, that'd be great. If not, then 2 weeks. He allegedly, he apparently has 4 additional charges that are in warrant review that the people have to
They have 4 additional charges
correct.
that are coming down the pike.
Correct. And we're trying to do something with his housing situation and verify that information. We're gonna make a bond motion. So if we can come back in a week or 2, that'll be very helpful.
Probable cause conference will be during May 2nd, 2024, 9 a.m. or 9 a.m. Bond continues. Court calls the case People versus Daly.
And Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Lee. Am I right, Mr. Lee? State your name for the record.
My name is Dan Lee.
Okay.
Your Honor, I'm just going to request 2-week adjournment here. He needs
Here
to,
as opposed to someplace else?
well, when we.
No, never mind. 2 weeks?
Please.
Your Honor, I do want to let the court know that, no, there's good news and bad news.
Okay.
There have been no contact to the victim from the jail whatsoever that I have been able to find, which is a step in the right direction. Bad news, I authorized a new case against Mr. Lee yesterday for controlled substance possession. I believe it's possession of meth as well as possession of cocaine. The offense date on that is February 24th of this year. I believe it's when he was taken into custody on this DV. It was found on his person. That has not been typed up yet, so this was just authorized yesterday. But I have let our legal assistants know, and they're expediting that so it can catch up along with these.
Probable cause conference. Are these the only other cases holding him?
Yes, Your Honor.
Yes, Your Honor.
Well, I'll
Oh,
adjourn.
no, he has an ice hold.
Well, the attorney,
Just that.
So technically, these are the only cases, but he has the ice hold.
Ace hole. May 9th, 2024, 9 a.m. Bound continues. Thank you.
thank you.
Calls case of the people versus Devon Miley.
Devin Calamine.
Judge, this is gonna be a straight waiver. He has other matters.
On both cases.
Yes, Judge. Did you want him to
Pardon?
sign the waiver, or are you gonna do it on the record?
You didn't get it signed.
Not
You
yet.
didn't do it.
I'm doing
Oh.
it.
Your piece, first time pieces showed up? Okay, that's why he doesn't know. All right.
Austin, Judge, if you sign,
All right.
it-
Just wondering, I didn't know. Must seem kind of new to you.
No.
All right, sir. You're waiving your right to have a preliminary examination in these matters.
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed
Yes.
and that you committed them.
Yes, Your Honor.
You understand you'll not have that here. You'll proceed to circuit court for further resolution.
Yes.
All right, people also waive their right on these matters.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count in each case with count 2 following in the matter ending in 5066.
Thank you, Judge. He'll waive formal reading instead. He wanted me to notify the court that his next court date at circuit court is May 7th.
It's what day?
May 7th is his date at circuit court for his other matters.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea in each of these cases. What pretrial date do we have?
I have April 30th.
Let's-
But May 7th is the date on shoot, so.
May 7th, 2024, 1:30. Bond will.
Good luck to you, bro.
Yes, thank you.
All right, take care. Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, sir. Clerk calls the case of the people versus LaJean Vincent.
Good morning, Your Honor. Amy Rice on behalf of the-
Bridget Coons on behalf of Mr. Vinston, state your name for the record. Honor, we'd like to set this one for preliminary examination.
All the discovery is complete.
Yes, Your Honor.
And would the people have their witnesses available the 30th? All right. Preliminary examination in person will be set April 30th, 2024, 9 a.m. That is in front of Judge Barr. Bond will continue. Thank you.
Yeah, they have that.
Court calls the case, people versus Jonathan Jackson.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief of Defender, appearing with and on behalf of Mr. Jackson. Mr. Jackson.
Give me.
Jonathan Eliezer Jackson.
All right, thank you. And you're asking for a forensic evaluation?
We are, Your Honor.
All right, forensic evaluation is ordered. I've signed the order. I'll set a hearing on that July 18th, 2024, 9 a.m.
Thank you, Your Honor. My client has asked me to address the issue of bond in this case.
Okay, briefly.
He does not have any prior criminal history.
Pardon?
He does not have prior criminal history. He does have a home in the area. he will return to all future court dates. We do feel that the charge here is probably somewhat high, given the facts and circumstances. We believe that once this matter is heard, that my client will not be convicted of a carjacking offense. We're asking that the bond, he be allowed a tether.
I understand the necessity to request it, but I also have a life offense. I got a capital offense here, and his bond is only 25,000 cash surety. So I don't need a response to people. Motion for bond reduction in this matter is denied.
Thank you.
We'll continue. Court does call the case. People of the state of Michigan versus William Mendoza.
Se llama en el estrado el caso de el estado de Michigan versus el señor William Mendoza.
Nicole Hughes on behalf of the people.
Nicole
Did you-
Dietz de parte del estado.
Did you hear that, Madam Interpreter?
I was able to, yes, Your Honor. Thank you.
All right, thank you. Go on.
Bridget Coons on behalf of Mr. Mendoza.
Bridget Counts de parte del señor Mendoza.
Your Honor, we'd be asking for an adjournment here.
Su señoría, estamos solicitando un aplazamiento, por favor.
I did submit a social worker request for medical records. And there is a possible offer available if we're able to obtain those.
Estoy solicitando una cita con la trabajadora social para pedir los expedientes médicos. Hay una posible oferta si eso fuera posible.
Which time did you need?
3 weeks.
El tiempo sería 3 semanas.
Probable cause conference will be adjourned to May 16th, 2024, 9 a.m. I'm sorry, Madam Interpreter.
Thank you, Your Honor. Entonces el caso se va a aplazar para la fecha del 16 de mayo de 2024 a las 9 en punto de la mañana.
Bond will continue.
Y la fianza no continúa.
Thank you.
Thank you.
Muchas gracias.
Thank you, Madam Interpreter. Do appreciate it. Court calls case People versus Teresa Johnson. Johnson, look up this way. Thank you.
Hi, Justin.
Hello, how are you?
I'm okay. How about yourself?
Thank you.
Thank you.
Bridget Coons on behalf of Ms. Jackson, state your name.
Teresa Johnson.
All right.
Your Honor, we'd be setting this one for a preliminary.
All discoveries complete.
Yes, Your Honor.
People have their witnesses available the 30th.
All of the gentlemen are standing on, so I just want to check the note. I don't see any notes saying 30th phone works.
Okay, fantastic. Preliminary examination in person will be set April 30th, 2024, 9 a.m. before Judge Freshour. All right, bond will continue.
Okay.
All right, thank you.
Take care of yourself.
You do the same.
Thank you, sir.
Let's call the case of the People versus Dion Leonard.
Andrew Tillers appearing on behalf of the people. Your Honor, Michael Vincent on behalf of Dion Leonard. Today's date time set for probable cause conference. There are 2 missing videos that I need before I can make a decision which way to go. And they're the videos
How
of
come you're
officers.
always missing videos?
I'm missing a lot of things. Sean.
Okay.
Missing my youth is what I'm mainly missing. Officer Gorman, Gorman, and training, apparently he is a newbie. Officer Alexopoules. Common spelling. Oh.
All right. And so you want an adjournment?
Yes.
All right. May 2nd. Well, May 9th,
Very nice. Thank you.
2024, 9 a.m.
9 a.m.
Yes.
That's subject to change possible. The time.
Oh, it is.
Thank you.
Continued. Thank you, sir. Court calls case People versus Anthony Lebowski.
Bridget, Cook, on behalf of Mr. Lebowski, if you can state your name for the record.
Anthony Lebowski.
Thank you.
Yeah, we'd be asking for a short adjournment on this. He was referred to mental health court. There's an issue where they need lien. I think I found out a resolution where Mr. Ganatra can talk to the mental health court to get that resolved, and then we can get him finalized.
Well, that's a 52nd District Court, correct?
Yes,
They received the referral. He appears to be eligible. They need a copy of the pre-sentence investigation with criminal history.
yes. So whenever I spoke to them, because I got the copy of the letter too. Whenever I spoke to them, the issue is, from my understanding, that they need a copy of lien. And
No, and you can't.
yeah, I
Got
can't
it.
get that.
Then you
But
gotta
Mr.
figure-
Ganatra did express that he'd be able to speak with the court directly, 52nd, about that to try to get it resolved.
Yeah, okay,
Yeah.
very good.
And thank you for that.
I'm happy to speak with them about confirming. But I can't.
Can't, correct. Okay, I'll let you guys work that out. May 2nd, 2024, 9 a.m. Bond continue. Thank you, sir.
Thank you, Your Honor.
Case People versus Demond Harris.
The court shall please to assist the whole defender appearance on behalf of, but not with, Mr. Damon Harris.
Done Zoom.
Oh, awesome.
Nimish Ganatra on behalf of the people for Children's.
Thank you, Judge.
Mr. Harris, can you state your name, please?
Yes, my name is Demond Harris.
Thank you. All right.
I did speak to Mr. Childers on this file, and we did receive a offer to resolve this matter. Mr. offer to resolve this file. I had not spoken to Mr. Harris. My understanding is that he is at home of New Vision in treatment.
Got it.
So I need to adjourn this to communicate the offer to him and hopefully get this wrapped up.
All right. I'll adjourn it May 9th, 2024, 9 a.m. Bond continued. All right.
I'll be in touch, Mr. Harris. Call me at the office.
What's your name?
Feaster, like Easter with an F.
Oh, Easter?
Easter.
Okay. I'll call you
Yes.
tomorrow. I get discharged tomorrow.
Yes, sir. Thank you.
All right.
Thank you, Judge.
Court calls the case People versus Kirsten Heron.
She should be appearing by Zoom.
She is.
All right, Your Honor.
Miss Heron, can you state your name, please?
Yes, this is Kirsten Heron.
Thank you, Your Honor. I'm going to ask for an adjournment, to continue plea negotiations and review the files with.
Probable cause conference, May 9th, 2024, 9 a.m. Or as your invite indicates, bond continued. Court calls case People versus Reginald Harris.
Good afternoon, Your Honor. Andrew Meyer on behalf of Reginald Harris. Mr. Harris, please state your name for the record.
Reginald Harris.
Thank you, Mr. Harris. Your Honor, this is the time and date set for a probable cause conference. I did have an opportunity to speak with Mr. Harris and Ms. Willingbring regarding this case. We just need a little more time to complete negotiations, at least 2 weeks, please.
Probable cause conference, May 9th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. All right. Sergeant Burgess?
Hello, Your Honor.
Hello.
Hello.
You wanted to swear out a count 2 on the Harrison matter, correct?
Yes, sir.
All right. Can you raise your, court does call the case of People State of Michigan versus Sarah James Harrison. Can you raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. State your name, your department, and please tell me what you know about this matter, please.
My name is Sergeant Burgess with the City of Ypsilanti Police Department. In regard to this matter, subject was stopped at a traffic stop with EMU PD on 6/8/2023 at 01:55 hours in the area of North Washington and Washtenaw Avenue. During the investigation of the traffic stop, it was revealed that the subject, Harrison, had on his person the financial transaction device for Kenneth Grandin. And it looks like he had 1, 2, 3, 4 credit cards with the name Kenneth Grandin on it in his possession.
And to your knowledge, or based upon the investigation, those financial transaction devices were in his possession without the consent of Mr. Grandin. Is that correct?
Yes, sir.
All right, very good. Based upon that, the court does find that there's probable cause, believe that the individual alleged in the complaint has committed the offenses alleged in, or the offenses alleged in the complaint. I will amend the complaint and authorize the second charge.
Thank you, Your Honor.
All righty, thank you.
Have a good day.
You do the same. Stay safe, please. Court does call the case of the people versus Trinaja Williams. I mean, no, good to see you. It just came out. It just came out all right.
That's okay. Good afternoon, Your Honor. Christina Costantino appearing with and on behalf of Ms. Williams, who's present and standing to my right. Ms. Williams, can you state your name for the record?
Trinaja Williams.
Thank you.
Your Honor,
Go ahead.
the date and time set for a probable cause conference. I was, at this time, we are asking for an adjournment. I was just appointed on this matter, I believe yesterday or 2 days ago. I do not have any discovery at this time, so we will need an opportunity to get all discovery and review the same.
All right. Probable cause conference will be adjourned without objection to May 9th, 2024, 9 a.m. Or as your invite indicates, bond will continue.